All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in ceremonial session. All we have cause to plead. Draw near, give attention, you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida.
On behalf of the Florida Supreme Court, it is my great privilege to welcome all of you today to this virtual ceremony honoring the centennial of the adoption of the 19th Amendment to the Constitution of the United States, which guaranteed women's suffrage throughout our land. We are especially honored to be joined in this ceremony today by representatives of both the executive branch and the legislative branch of Florida's government. And we are very grateful to the Florida Bar under the outstanding leadership of President Dori Foster-Morales for undertaking the work necessary to produce this event so that as the year 2020 draws to a close, we can join with all those in Florida who over the course of this centennial year have in various ways celebrated the monumental impact of women's suffrage on our life as a nation. The adoption of the 19th Amendment was indeed a critical step forward in our quest as a people to more fully realize the promise in the preamble of the United States Constitution to establish justice and to secure the blessings of liberty to ourselves and our posterity. It took a national movement of determined women to attain the goal of a national constitutional guarantee of the right of women to vote. Today, we honor and celebrate them for their contribution to the cause of justice and liberty. And we honor and celebrate all the women who since then have contributed to shaping and improving our life as a people, particularly those who have enriched the legal profession, our court system, and all our institutions of government. The impact of the empowerment of women gained through the franchise on our legal system, our courts, and all our governmental institutions was slow but profound. Ultimately, it worked a great transformation. Now we will move on to our speakers who will reflect on this legacy of women's suffrage. First, it is my great honor to introduce to you the Lieutenant Governor of the state of Florida, Jeanette Nuñez, who also serves as chair of the Florida Women's Suffrage Centennial Commission.
Hello, this is Lieutenant Governor Jeanette Nuñez. Thank you for joining me as we celebrate the landmark 100th anniversary of the ratification of the 19th Amendment. This is a historic occasion that is worthy of celebration and commemoration. This year, I had the distinct honor to chair Florida's Women's Suffrage Centennial Commission. Our commission was made up of incredibly talented and dynamic women from across the state of Florida, with whom I was proud to serve. During my time as chair of the Centennial Commission, I developed a deep appreciation for the women who fought tirelessly for our right to vote. Learning about the history of the amazing suffragists gave me a newfound respect for their advocacy and their legacy. The particular stories that spoke to me the most were the bold women who fought for the right to vote here in the great state of Florida. While we may all be familiar with Susan B. Anthony and the women of Seneca Falls, there are countless female leaders who carried the torch in our home state and deserve to be remembered. Outstanding women like Ella Chamberlain from Tampa, who wrote a newspaper column dedicated to women's rights. Seen as the pioneer of the suffrage movement in Florida, Ellen helped found the Florida Women's Suffrage Association and served as its president for many years. Or other tireless fighters like Mary Nolan from Jacksonville, who was a leader in the National Women's Party. Or Mary McLeod Bethune, who championed voting rights and education for all people, regardless of their race or gender. These incredible women are part of the reason why we have the sacred right to vote today. I hope that we can all appreciate their contributions, celebrate their successes, and build upon their legacy of strong leadership. If you would like to hear more about these amazing women and more just like them, please visit womensvote100.org/Florida to learn more and gain other valuable information about the 19th Amendment's Centennial right here in Florida. Thank you, and God bless the great state of Florida.
Now I have the distinct privilege of introducing my wife, Jennifer Canady, who serves on both the Florida Women's Suffrage Centennial Commission and the Florida Commission on the Status of Women.
May it please the court. Thank you for the kind invitation to participate in this ceremonial session. I'm delighted to join such an extraordinary group in such a worthy undertaking. For unity and symbolism, what we'd call branding today, in the 1800s in our country, the colors purple, white, and golden yellow were used in signs, pins, ribbons, sashes, and other campaign items. In 1913, the Suffragist, the newspaper of the National Women's Party, described the symbolism of those three colors: purple for loyalty, white for purity and quality of purpose, gold for light and life, and as the symbol of the torch, which was significant to the movement. And then in the summer of 1920, there were 35 states that had ratified this amendment to the Constitution, giving American women from east to west the right to vote. But there was just one more needed to add it to the United States Constitution. And so those suffrage colors of yellow especially became even more significant during the battle for ratification of the Susan B. Anthony Amendment. Now, in the state of Tennessee, after the re-election of Governor A.H. Roberts, the public support for the suffrage movement was gaining momentum, and he called a special session. And during this special session for the ratification of the Susan B. Anthony Amendment, there were intense lobbying efforts on both sides, waged what was called the War of the Roses, with pro-suffrage legislators wearing yellow roses and anti-suffrage legislators wearing red boutonnieres instead. One observer of the legislature kept account, and it became very clear that the vote would be extremely close. Over the 8 days of debate, it was clear that it was coming down to just the smallest margin, such a close vote. On August 18th, the youngest member of the State House, Harry T. Byrne, wearing a red boutonniere on his lapel, had received a letter from his mother. And in this letter, his mother said, "Harry, be a good boy and vote for suffrage." And so Harry shocked the entire crowd gathered in the gallery when, in a loud voice and wearing that red boutonniere indicating that he was opposed to suffrage, said, "I." And not only did he vote for suffrage, but he actually recruited a good friend of his who had also been opposed to suffrage, named Banks Turner. And when Banks Turner also voted aye, that carried the day. And the resolution was passed and suffrage became the law of the land. 72 hours later, the suffragists tore off their roses, threw them in the air, and petals rained down as they celebrated the passage of the Susan B. Anthony Amendment. Now, 100 years later, suffrage celebrations all across the country feature yellow roses to commemorate the suffragist struggle. The Pew Research Center tells us that in elections today, women make up more than 50% of the vote, voting at higher rates than men, and the number of women in public service increases every day. In closing, I'd like to thank the Florida Bar President Dori Foster-Morales for supporting celebrations of suffrage. Now, the plan at the Florida Bar Convention this summer was to have hundreds of lawyers and judges wearing yellow boutonnieres in honor of women's suffrage. Because of COVID, that wasn't possible, but we thank the bar and all of those who have worked so hard to commemorate this important milestone. I am grateful. It has been my honor to serve on the Florida Women's Suffrage Commission and the Florida Commission on the Status of Women on this very important year celebrating this milestone in our country. Again, thank you very much for the opportunity to join in this celebration.
At this time, I'm very pleased to recognize here at the bench the most recent appointee to the Florida Supreme Court, Justice Jamie Grosshans.
I am honored to be with you today as we celebrate the 100th anniversary of the 19th Amendment's passage and the remarkable women that have helped shape Florida's legal community. 2 years after the 19th Amendment was ratified, Bessie Bellinger became the first female judge appointed in Florida. This was an amazing event, noted at the time by the Women's Law Journal when they said, "Elevating women lawyers to the bench testifies to their status in the profession, but in a Southern state, it means more than that. It means the last barriers to equal opportunity for men and women give way before the onsweep of progressive thought." In the years following the 19th Amendment's passage, the number of female attorneys in Florida continued to grow, but it was not until 1974 that Susan Black was appointed as the third female judge in Florida. As the drive for recognition and equality continued within the legal system, the 1980s brought several significant events. Sandra Day O'Connor became the first female appointed to the United States Supreme Court. Leah Sims became the first African-American female appointed to the judiciary in Florida. We also saw several Cuban-American females appointed and elected throughout the state, as well as several women appointed to Florida's appellate courts. And in 1985, Rosemary Barquette became the first female justice of the Florida Supreme Court. At that moment, 150 years of Mr. Justice turned simply to justice, and we ushered in a new era where women continued to seek leadership roles within Florida's legal system. The past 10 years alone have seen a dramatic increase, with 43% of judicial appointments going to women. Today, women make up over 40% of Florida's judiciary, serving across the state with distinction at every level. They manage dockets, they serve their communities, they engage in civic activity, they lead task forces, they volunteer on committees, and they spend countless hours training new generations of attorneys. As we look at this remarkable achievement, I am reminded of Sandra Day O'Connor's words when she said, "Society as a whole benefits immeasurably from a climate in which all persons, regardless of race or gender, may have the opportunity to earn respect, responsibility, advancement, and remuneration based on ability." Now, 35 years after Justice Barquette's appointment, I sit at the same desk at which she once labored and follow in the footsteps of the 3 other women who have faithfully served in this role. I am a grateful beneficiary of the suffragettes' fight and that on-sweep of progressive thought predicted 100 years ago. Thank you for joining us today as we celebrate this historic event.
It is now my privilege to recognize Dori Foster-Morales, the President of the Florida Bar, for remarks.
May it please the Court. Mr. Chief Justice, members of the Florida Supreme Court, thank you for the opportunity to speak about the history and impact of Florida's women lawyers. I am so honored to be here today celebrating the 19th Amendment Centennial alongside so many great leaders and trailblazers in their own right. When the 19th Amendment was ratified on August 18th, 1920, there had been 22 women admitted to practice law in the state of Florida. Today, there are 35,000 women lawyers in Florida who are eligible to practice law and in good standing. These numbers show us that there has been a tremendous progress over the years in terms of gender diversity in the legal profession, but there is still work to be done. If we are to continue making progress, it is important to reflect on our past and remember how we got here. Louise Rebecca Pinnell. She was Florida's first woman lawyer, having been admitted to Florida in 1898. She studied in her father's law office for 2 years until taking and passing the bar exam. Ms. Pinnell's incredible career spanned 60 years and mainly focused on railroad law. She was highly respected and well-known in legal circles throughout the state of Florida. Ms. Pinnell opened the door for all future women lawyers in Florida, fiercely advocating society's perception of what women could and could not do. In 1958, she was quoted as saying, "Women have proved that they can go into almost any field and be successful if they work at it." Currently, women make up 40% of the Florida Bar members who are eligible to practice law in good standing. When I joined the Florida Bar Board of Governors in 2008, the percentage of women on the board was 19%. Today, women make up 30% of the Board of Governors and 44% of Bar Committee leadership. As we look towards the future, the Florida Bar remains committed to the enhancement of diversity and inclusion within the bar, the legal profession, legal education, and the justice system. Seeing other women leaders in the profession has been a critical part of my journey to becoming president of the Florida Bar. Patricia Seitz was the first female president of the Florida Bar, and that occurred in June of 1993, a relatively recent milestone approximately 27 years ago in the bar's 70-year history. I remember when Judge Seitz was elected. I was a young prosecutor, pregnant with my daughter, Nora. I had just moved back to Florida. And I certainly was excited that the bar would be led by a woman, finally. But you know what? Even that was a contested election. So 50 years into our history as a bar, it was still not universally accepted that it was high time for a woman to become president. I've been so lucky to have so many great mentors, and in particular, female mentors in the practice of law that have played an incredibly significant role in my career, guiding and encouraging me along the way. I was first hired in Florida by Janet Reno, obviously the first female attorney general in the United States. She encouraged me to return to Miami and become a prosecutor. I was then fostered and mentored by Catherine Fernandez-Rundle, the state attorney of Miami-Dade County, where I tried over 70 cases to jury trial with a young daughter in tow. Thereafter, my mentor in the private sector was Marcia Elser. She was the first female president of the American Academy of Matrimonial Lawyers nationally, and she really gave me a start in family law. And finally, Patricia Seitz herself mentored and encouraged me to run and become the president of the Florida Bar. All of these women gave me the courage to believe I can do it. Now, as only the 7th woman to serve as the president of the Florida Bar, I am truly indebted to the brave suffragettes who had the strength to shatter the most significant of all glass ceilings, guaranteeing the women the right to vote. I am so incredibly grateful to the many inspirational women, lawyers who have come before me. Like the rest of the Constitution, the 19th Amendment is a living document that challenges us daily to continue to aspire towards the ideals and principles embodied in that amendment. We must keep striving for greater diversity and inclusion in the legal profession to open the doors even wider to future women lawyers. I look forward to that. Thank you so much.
At this time, I'm honored to recognize State Representative Fentrice Driskell, a member of the Florida Women's Suffrage Centennial Commission.
May it please the court. Mr. Chief Justice, members of the Florida Supreme Court, thank you so much for the honor of allowing me to address you today. We honor and celebrate the fact that women gained the right to vote 100 years ago. It is important to note that for Black women and other women of color in this country, that right came much, much later. Black women were very active in the women's suffrage movement. On March 3, 1913, the members of Delta Sigma Theta Sorority Incorporated, of which I am proud to be a member, participated in the Women's Suffrage March in Washington, D.C. Several other Black women participated as well, and they, along with the members of Delta Sigma Theta, were relegated to march in the back. And these events were not pretty little parades with floats and fanfare. They were marches with crowds of angry men pressing on both sides, at times turning violent. So it was both an empowering but also a threatening atmosphere for women to participate in these marches. And how much more so must it have been that way for Black women who had to deal with the dual reality of both being a woman and a person of color. Even though Black women fought alongside white women for this all-important right, they wouldn't be granted the freedom to vote until the passage of the Voting Rights Act in 1965. So as I share my remarks on how far women lawyers have come since the passage of the 19th Amendment with respect to public service, I want you to keep this context in mind, specifically with respect to the amazing strides made by Black women against this legal and political backdrop. And remember that for some women, the runway to achieve this success was much, much shorter. A second historical point that I wanted to note is that Florida itself had a checkered history with the 19th Amendment. Most women's suffrage groups in Florida supported only white women gaining the right to vote. Even so, women's suffrage was slow to gain widespread traction throughout the state. In fact, the Florida legislature had the opportunity to be amongst the first states to ratify the 19th Amendment in 1919, but instead decided to adjourn despite a plea from the governor to ratify it. Florida ultimately ratified the 19th Amendment 50 years later on May 13, 1969. The first woman member of the Florida House of Representatives was Edna Giles Fuller, who was sworn in on April 2, 1929. She represented Orange County. It would take until 1942 for Florida to elect its second woman to the legislature, Mary Lou Baker, who was also the first woman lawyer to serve. She was from Pinellas County. According to the book, Women in the Florida Legislature, in her first term, Baker was the sponsor of 3 major bills relating to women, making it lawful for women to serve on juries, which unfortunately failed, authorizing the use of powers of attorney executed by husband or wife, which passed in the Senate but failed in the House, and permitting married women to manage their separate property and to make contracts, which passed in both houses. In 1970, Gwen Sawyer Cherry from Miami became the first African-American woman ever to serve in the Florida House of Representatives. Representative Cherry was also the first Black woman lawyer to serve. She graduated from Florida A&M Law School cum laude. Of note, Representative Cherry was only the second Black woman admitted to practice law in the state of Florida, and she was the first Black woman attorney to practice in Dade County. The Senate gained its first woman, with the election in 1962 of Beth Johnson of Orlando. She had served in the Florida House of Representatives since 1957. It would take until 1979 for the Florida Senate to elect its first Black woman member, Carrie Meek. She also was the first Black member to serve in the Senate since Reconstruction. In 2006, Arthenia Joyner, who is only the 5th Black woman lawyer admitted to the Florida bar, and who was the first Black woman attorney to practice in Hillsborough County and in Polk County, became the first Black woman lawyer elected to the Florida Senate. Lawyers have always played an important role in the Florida legislature. In fact, for the 2020-2022 term, there are 33 attorneys serving in the Florida House, of which 9 are women. There are 10 attorneys serving in the Florida Senate, of which 5 are women. As you can see, we've come very far, but we still have a long way to go. So I would like to encourage my colleagues to stay vigilant, stay aware of gender bias, and do everything and anything you can to interrupt those biases when you see them. Together, we can work towards building a more equitable and just society for all. Thank you.
We will now proceed with a virtual tour of an exhibit titled 100 Years After the 19th Amendment, Their Legacy and Our Future.
The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. 2020 marks 100 years since those words were ratified, becoming the 19th Amendment to the United States Constitution. The speakers you are about to hear from will highlight the events that led to the passage of the 19th Amendment, along with the fight for true equality under the law that followed for many years thereafter. The common thread of the women's suffrage movement has been the brave leaders who stood up for equality, challenged the status quo, and opened doors for future generations. We will forever be indebted to these trailblazers, and we owe it to them to share their stories and continue striving for greater diversity and inclusion in the legal profession and beyond.
The Seneca Falls Convention, held in 1848, is known as the meeting that launched the women's suffrage movement in America. Suffragists, including Lucretia Mott and Elizabeth Cady Stanton, convened a meeting of more than 200 women and 40 men in Seneca Falls, New York. Stanton read the Declarations of Sentiments and Grievances, which detailed the injustices inflicted upon women in the United States and called upon women to organize and petition for their rights. The Declaration was adopted and signed along with 12 resolutions that called for equal rights for women.
After the Seneca Falls Convention, a series of women's rights conventions were held during the 1850s. These conventions eventually led to the formation of the American Equal Rights Association, which included white and Black women and men dedicated to the goal of universal suffrage. Throughout the late 1800s and early 1900s, suffragists organized, advocated, and even performed acts of civil disobedience to achieve suffrage. The 19th Amendment to the Constitution, providing for the right to vote for women, was adopted by Congress in 1919 and sent to the states for ratification. From there, it had to be ratified by 3/4 of the states, which at the time was 36 out of 48 states. Finally, in 1920, Tennessee became the 36th state to ratify the 19th Amendment, and the amendment was added to the United States Constitution.
While many suffragists left public life after the passage of the 19th Amendment, some, like Alice Paul, believed the battle for women's equality had yet to be won. In 1922, she authored the text of what would become the Equal Rights Amendment, which was designed to guarantee equal legal rights for all American citizens, regardless of sex. To this day, the Equal Rights Amendment has not been ratified to the Constitution, although there has been a renewed push to adopt the amendment in recent years. Aside from efforts to amend the Constitution, equal rights activists have also sought legislative reform. Examples include the Equal Pay Act of 1963, which prohibits gender-based wage discrimination, and the 2008 Fair Pay Act, which allows workers who face pay discrimination to pursue legal remedies in federal court.
Although it was a remarkable expansion of democracy, the 19th Amendment still left many people behind. Chinese Americans were not granted citizenship and therefore could not vote until the repeal of the Chinese Exclusion Act in 1943. However, immigration restrictions targeting Asian countries remained in place until the passage of the Immigration and Nationality Act of 1965. Throughout the early and mid-20th century, Native Americans eventually won the right to vote by fighting for it, state by state. African Americans faced Jim Crow era suppression from Reconstruction into the 1960s. Civil rights leaders, including Dr. Martin Luther King Jr. and Fannie Lou Hamer, advocated for legislation that would prohibit racial discrimination, culminating in the passage of the Civil Rights Act of 1964 and the Voting Rights Act of 1965. In 1990, Congress passed the American with Disabilities Act, requiring that polling centers have accommodations for individuals with disabilities.
Federal, state, and local lawmakers have enacted reforms to expand access to the ballot, including early voting. Recently, organizing efforts by women have fostered a new wave of women's rights advocacy. In January 2017, millions of people around the world participated in the Women's March, one of the largest peaceful demonstrations in history, demanding civil and voting rights equality. A century after the ratification of the 19th Amendment, voter disenfranchisement continues spurring lawyers, bar associations, judges, and other legal professionals to lead the nation in pursuing justice for all and demanding liberty.
We've now come to the conclusion of today's ceremony in celebration of women's suffrage and all it has meant to our state and nation. I want to thank Lieutenant Governor Nuñez, Representative Driskell, President Foster-Morales, Justice Grosshans, and Commissioner Canady for their presentations today. And thanks to all of you across Florida who have joined us for this ceremony. Finally, thanks to all those throughout our state and nation who continue to labor in the cause of more fully establishing justice and securing the blessings of liberty to ourselves and our posterity. This ceremonial session is now adjourned.